Hi, you're listening to the final part of the 2019 proposed amendments to the revised rules and evidence to take effect on May 1st, 2020. Please don't forget to hit that subscribe button. It's gonna fuel this channel. Thanks a lot. Section 15 of Rule 132, Exclusion and Separation of Witnesses. The court, motu proprio or upon motion, shall order witnesses excluded so that they cannot hear the testimony of other witnesses. This rule does not authorize exclusion of a party who is a natural person, b. a duly designated representative of a juridical entity which is a party to the case, c. a person whose presence is essential to the presentation of the party's cause, or d. a person authorized by statute to be present. The court may also cause witnesses to be kept separate and to be prevented from conversing with one another directly or through intermediaries until all shall have been examined. Section 16. When witness may refer to memorandum. A witness may be allowed to refresh his or her memory respecting a fact by anything written or recorded by himself or herself, or under his or her direction, at the time when the fact occurred, or immediately thereafter, or at any other time when the fact was fresh in his or her memory and he or she knew that the same was correctly written or recorded. But in such case, the writing or record must be produced and may be inspected by the adverse party, who may, if he or she chooses, cross-examine the witness upon it and may read it in evidence. A witness may also testify from such a writing or record, though he or she retains no recollection of the particular facts, if he or she is able to swear that the writing or record correctly stated the transaction when made, but such evidence must be received with caution. Section 17. When part of transaction, writing or record, given in evidence, the remainder admissible. When part of an act, declaration, conversion, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into by the other, and when a detached act, declaration, conversion, writing, or record is given in evidence, any other act, declaration, conversion, writing, or record necessary to its understanding may also be given in evidence. Section 18. Right to inspect writing shown to witness. Whenever a writing is shown to a witness, it may be inspected by the adverse party. Letter B. Authentication and proof of documents. Section 19. Classes of documents. For the purpose of their presentation in evidence, documents are either public or private. Public documents are a. the written official acts or records of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or of a foreign country. Letter B. Documents acknowledged before a notary public, except last wills and testaments. C. Documents that are considered public documents under treaties and conventions which are in force between the Philippines and the country of source, and D. Public records kept in the Philippines of private documents required by law to be entered therein. All other writings are private. Section 20. Proof of private documents. Before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following means: a. By anyone who saw the document executed or written; b. By evidence of the genuineness of the signature or handwriting of the maker; or c. By other evidence showing its due execution and authenticity. Any other private document need only be identified as that which it is claimed to be. Section 21. When evidence of authenticity of private document not necessary. where a private document is more than 30 years old, is produced from a custody in which it would naturally be found if genuine, and is unblemished by any alterations or circumstances of suspicion, no other evidence of its authenticity need be given. Section 22. How genuineness of handwriting proved. The handwriting of a person may be proved by any witness who believes it to be the handwriting of such person, because he or she has seen the person write, or has seen writing purporting to be his or hers, upon which the witness has acted or been charged, and has thus acquired knowledge of the handwriting of such person. Evidence respecting the handwriting may also be given by a comparison made by the witness or the court with writings admitted or treated as genuine by the party against whom the evidence is offered, or proved to be genuine to the satisfaction of the judge. Section 23. Public documents as evidence. Documents consisting of entries in public records made in the performance of a duty by a public officer are prima facie evidence of the facts therein stated. All other public documents are evidence, even against a third person, of the fact which gave rise to their execution and of the date of the latter. Section 24. Proof of official record. The record of public documents referred to in paragraph A of section 19, when admissible for any purpose, may be evidenced by an official publication thereof, or by a copy attested by the officer having the legal custody of the record, or by his or her deputy, and accompanied, if the record is not kept in the Philippines, with a certificate that such officer has the custody. If the office in which the record is kept is in a foreign country, which is a contracting party to a treaty or convention to which the Philippines is also a party, or considered a public document under such treaty or convention pursuant to paragraph C of section 19 hereof, the certificate or its equivalent shall be in the form prescribed by such treaty or convention, subject to reciprocity granted to public documents originating from the Philippines. For documents originating from a foreign country, which is not a contracting party to a treaty or convention referred to in the next preceding sentence, the certificate may be made by a secretary of the embassy or legation, consul general, consul, vice consul, or consular agent, or by any officer in the foreign service of the Philippines stationed in the foreign country in which the record is kept, and authenticated by the seal of his or her office. A document that is accompanied by a certificate or its equivalent may be presented in evidence without further proof, the certificate or its equivalent being prima facie evidence of the due execution and genuineness of the document involved. The certificate shall not be required when a treaty or convention between a foreign country and the Philippines has abolished the requirement, or has exempted the document itself from this formality. Section 25. What attestation of copy must state. Whenever a copy of a document or record is attested for the purpose of evidence, the attestation must state, in substance, that the copy is a correct copy of the original, or a specific part thereof, as the case may be. The attestation must be under the official seal of the attesting officer, if there be any, or if he or she be the clerk of a court having a seal, under the seal of such court. Section 26. Irremovability of public record. Any public record, an official copy of which is admissible in evidence, must not be removed from the office in which it is kept, except upon order of a court where the inspection of the record is essential to the just determination of a pending case. Section 27. Public record of a private document. An authorized public record of a private document may be proved by the original record or by a copy thereof, attested by the legal custodian of the record, with an appropriate certificate that such officer has the custody. Section 28. Proof of lack of record. A written statement signed by an officer having the custody of an official record, or by his or her deputy, that after diligent search, no record or entry of a specified tenor is found to exist in the records of his or her office, accompanied by a certificate as above provided, is admissible as evidence that the records of his or her office contain no such record or entry. Section 29. How judicial record impeached. Any judicial record may be impeached by evidence of a. Want of jurisdiction in the court or judicial officer, b. Collusion between the parties, or c. Fraud in the party offering the record in respect to the proceedings. Section 30. Proof of notarial documents. Every instrument duly acknowledged or proved and certified as provided by law may be presented in evidence without further proof, the certificate of acknowledgment being prima facie evidence of the execution of the instrument or document involved. Section 31. Alteration in document. How to explain. The party producing a document as genuine which has been altered and appears to have been altered after its execution, in a part material to the question in dispute, must account for the alteration. He or she may show that the alteration was made by another without his or her concurrence, or was made with the consent of the parties affected by it, or was otherwise properly or innocently made, or that the alteration did not change the meaning or language of the instrument. If he or she fails to do that, the document shall not be admissible in evidence. Section 32. Seal. There shall be no difference between sealed and unsealed private documents, and so far as their admissibility as evidence is concerned. Section 33. Documentary evidence in an unofficial language. Documents written in an unofficial language shall not be admitted as evidence unless accompanied with a translation into English or Filipino. To avoid interruption of proceedings, parties or their attorneys are directed to have such translation prepared before trial. Letter C. Offer and objection. Section 34. Offer of evidence. The court shall consider no evidence which has not been formally offered. The purpose for which the evidence is offered must be specified. Section 35. When to make offer. All evidence must be offered orally. The offer of the testimony of a witness in evidence must be made at the time the witness is called to testify. The offer of documentary and object evidence shall be made after the presentation of a party's testimonial evidence. Section 36. Objection. Objection to offer of evidence must be made orally immediately after the offer is made. Objection to the testimony of a witness for lack of a formal offer must be made as soon as the witness begins to testify. Objection to a question propounded in the course of the oral examination of a witness must be made as soon as the grounds, therefore, become reasonably apparent. The grounds for the objections must be specified. Section 37. When repetition of objection unnecessary. When it becomes reasonably apparent in the course of the examination of a witness that the questions being propounded are of the same class as those to which objection has been made, whether such objection was sustained or overruled, it shall not be necessary to repeat the objection, it being sufficient for the adverse party to record his or her continuing objection to such class of questions. Section 38. Ruling. The ruling of the court must be given immediately after the objection is made, unless the court desires to take a reasonable time to inform itself on the question presented. But the ruling shall always be made during the trial, and at such time as will give the party against whom it is made an opportunity to meet the situation presented by the ruling. The reason for sustaining or overruling an objection need not be stated. However, if the objection is based on two or more grounds, a ruling sustaining the objection on one or some of them must specify the ground or grounds relied upon. Section 39. Striking out of answer. Should a witness answer the question before the adverse party had the opportunity to voice fully its objection to the same, or where a question is not objectionable, but the answer is not responsive, or where a witness testifies without a question being posed or testifies beyond limits set by the court, or such when the witness does a narration instead of answering the question, and such objection is found to be meritorious, the court shall sustain the objection and order such answer, testimony, or narration to be stricken off the record. On proper motion, the court may also order the striking out of answers which are incompetent, irrelevant, or otherwise improper. Section 40. Tender of excluded evidence. If documents or things offered in evidence are excluded by the court, the offerer may have the same attached to or made part of the record. If the evidence excluded is oral, the offerer may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. Rule 133. Weight and sufficiency of evidence. Section 1. Preponderance of evidence, how determined. In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issue involved lies, the court may consider all the facts and circumstances of the case, the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessarily with a greater number. Section 2. Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as, excluding possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Section 3. Extrajudicial confession, not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction, unless corroborated by evidence of corpus delicti. Section 4. Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if a. There is more than one circumstance, b. The facts from which the inferences are derived are proven, and c. The combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Inferences cannot be based on other inferences. Section 5. Weight to be given opinion of expert witness, how determined. In any case where the opinion of an expert witness is received in evidence, the court has a wide latitude of discretion in determining the weight to be given to such opinion, and for that purpose may consider the following: a. Whether the opinion is based upon sufficient facts or data. b. Whether it is the product of reliable principles and methods. c. Whether the witness has applied the principles and methods reliably to the facts of the case, and D. such other factors as the court may deem helpful to make such determination. Section 6. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Section 7. Power of the court to stop further evidence. The court may stop the introduction of further testimony upon any particular point when the evidence upon it is already so full that more witnesses to the same point cannot be reasonably expected to be additionally persuasive. This power shall be exercised with caution. Section 8. Evidence on motion. When a motion is based on facts not appearing of record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or deposition.